After studying this module, you shall be able to know the kind of meetings, learn the requisites of a valid meeting, identify the procedure of holding a meeting. Slide 7.
The rights of a member of a company to participate in fundamental corporate decision making and appoint their representatives as directors to run the company on their behalf are ensured by the general meeting of the company. General meetings, that is, the meetings of shareholders of the company, are required to be held from time to time. In this module, we are going to discuss the provisions of the Companies Act related to holding of annual general meetings of the company.
There are two kinds of general meetings. First, annual general meeting, that is AGM. Second, extraordinary general meeting, that is EGM. Let us now move on to discuss the annual general meetings, that is AGM. Annual general meetings is a regular meeting of the members of a company which is held annually. This meeting provides an opportunity to the members of the company to review working of the company and express their views on the management of the company. The purpose of calling the meeting is to transact the ordinary business of the company. The ordinary business of annual general meetings consists of A. The passing of the annual accounts. B. Declaration of dividends. C. Election of directors in place of those who are retiring by rotation. D. Appointment and the fixation of the remuneration of auditors of the company. Statutory requirement. It is a statutory requirement on every company to call and hold an annual general meeting every year. The first annual general meeting of a company must be held within 9 months from the closing of the first financial year of the company. Subsequent annual general meeting must be held by the company each year within 6 months after the close of the financial year, but the interval between any two annual general meetings must not be more than 15 months. Registrar may, however, for any special reason, extend the time within which any annual general meeting, that is, not being the first annual general meeting, shall be held by a period not exceeding 3 months. There should be one annual general meeting in every calendar year, and therefore there must be as many general meetings as the number of calendar years for which the company had been carrying on business. Time and place of the meeting. Company must call the annual general meeting on a working day during business hours, that is from 9 a.m. to 6 p.m., either at the registered office of the company or at some other place within the city in which the registered office of the company is situated. Default in holding the annual general meeting. If default is made in holding an annual general meeting in accordance with Section 96, the tribunal, that is, Company Law Board, may, on the application of any member of the company, call or direct the calling of general meeting of the company and give such ancillary or consequential directions as the tribunal thinks expedient in relation to the calling, holding, and conducting of the meeting. If default is made in holding a meeting of the company in accordance with Section 96 or in complying with any directions of the tribunal, the company and every officer of the company who is in default shall be punishable with fine which may extend to rupees 1 lakh, and in the case of a continuing default, with a further fine which may extend to rupees 5,000 for every day after the first during which such default continues. Extraordinary General Meetings, that is EGM. All general meetings other than the annual general meetings are known as extraordinary general meetings. When and by whom EGM may be called. Extraordinary general meeting may be called under the following circumstances: by the board, when the directors have to transact some immediate or emergent business for which they cannot wait till the next annual general meeting, that is, the board of directors of a company may call this meeting whenever it thinks the need of it. By the board on the requisition. The board of directors of extraordinary general meeting may also call an extraordinary general meeting on the requisition of given number of members. The given number of members is A. In the case of company having share capital, members or members holding not less than 1/10 of the paid up share capital of the company carrying voting rights regarding the matter of the requisition. B. In the case of a company not having share capital, member or members holding at least 1/10 of the total voting power of all the members at the date of the deposit of the requisition regarding that matter.
Requisitionists shall call the meeting in the same manner as nearly as possible to that in which meetings are to be called by the board of directors. Notice of such meeting shall be given in the same manner as for the regular meetings. If the registered office is not made available to them, they may hold the meeting anywhere else. Requisitionists shall be entitled to claim all the expenses from the company of calling a meeting on the default of the directors to do so. The company shall be entitled to indemnify itself and to deduct any sum so paid to the requisitionists to mete out the expenses of calling a meeting on the default of the directors to do so out of the fee or remuneration of those directors who were in default. Resolution properly passed at a meeting called by the requisitionists shall be binding upon the company.
The requisites for calling and conducting the valid general meetings are proper authority. The authority to call a general meeting is the board of directors of the company. The notice of the meeting should be issued under their authority granted at a duly constituted meeting of the board or passing a resolution by circulation. A single director has no power to convene a meeting. The secretary of the company has no authority to call a general meeting unless the board resolves and authorizes him to do so. However, under certain circumstances, the requisitionist, the tribunal, may call a general meeting in the case of default by the directors. Notice. Notice of every meeting should be given to the following persons. First, every member of the company. Second, every person entitled to a share in consequence of the death or insolvency of a member. Third, auditor or auditors of the company. Fourth, every director of the company. Deliberate omission to give notice to a single member may invalidate the meeting. However, an accidental omission to give notice to or non-receipt of it by a member will not invalidate the meeting. Length of notice. A proper notice in writing to every member of the company is required by law for the holding of every valid meeting. Notice must be fair and clear. It must disclose the purpose for which the meeting is called. It must be given at least 21 clear days before the date of the meeting. In calculating 21 days, the date of receipt of notice and the date of the meeting should be excluded. Articles may provide for a notice longer than 21 days, but not for a notice shorter than 21 days. The notice shall be deemed to have been received by a member at the expiration of 48 hours from the time of posting. A general meeting may be called at a short notice if a. If the company has a share capital, members holding 95% of the paid-up share capital carrying voting rights exercisable at the meeting agree. B. If the company does not have a share capital, members holding at least 95% of the total voting power exercisable at the meeting agree. The consent of the members for shorter notice may be obtained either in writing or through electronic mode at the meeting or before the meeting. Service of notice. Company may serve notice on the members either personally or by prepaid post or by electronic mode, by advertisement in the newspaper. It must be properly addressed. Service of notice by advertisement shall be deemed to be complete the day when the advertisement appears in the newspaper on both resident and non-resident members. Contents of the notice. The notice must contain the following particulars. First, it should specify the name of the meeting, the place, day, and hour of the meeting, and the meeting to be valid must be held at the place and time specified. Second, it should also specify the nature of the business to be conducted at the meeting, that is, A. General business. In case of annual general meeting, all business relating to the consideration of annual accounts, the declaration of a dividend, the appointment of directors in place of those retiring, and the appointment of and the fixing of remuneration of the auditors are considered as general business. B. Special business. Any other business at an annual general meeting and all business in case of any other meeting are regarded as special business. In special business is to be transacted an explanatory statement giving all the material facts of the item of special business, including the particulars of interest in any of every director or other managerial personnel, must be annexed to the notice. Quorum. Minimum number of members required to constitute a valid meeting and to transact business legally therein is called quorum. No meeting can be valid without quorum. Any resolution passed at a meeting without quorum shall be invalid. Section 103, subsection 1st of the Companies Act provides that first, unless the articles of the company provide for larger number, a. In case of a public company, 5 members personally present if the number of members as on the date of meeting is not more than 1000. 15 members personally present if the number of members as on the date of meeting is more than 1000 but up to 5000. 30 members personally present if the number of members as on the date of the meeting exceeds 5000. Second, if the quorum is not present within half an hour from the time appointed for holding a meeting of the company, a. The meeting shall stand adjourned to the same day in the next week at the same time and place, or to such other date and such other time and place as the board may determine, or b. The meeting, if called by requisitionist under section 100, shall stand cancelled. Third, if at the adjourned meeting also a quorum is not present within half an hour from the time appointed for holding meeting, the members present shall be the quorum.
Let us now discuss the provisions, roles, and responsibilities of the chairman. A general meeting of the company is to be presided over by a chairperson who regulates and supervises the proper conduct of the businesses at a meeting. He decides all incidental questions arising in the course of proceedings of the meeting. Chairpersons should act bona fide and in the best interest of the company as a whole. Articles of association usually provide the mode of appointment of chairperson of a meeting. If the articles of associations do not provide, otherwise the members personally present at the meeting shall elect one of themselves to act as a chairperson thereof on a show of hands. If a poll is demanded on the election of the chairperson, it must be taken forthwith, and the chairperson elected on a show of hands can exercise all the powers in this connection. If some other person is elected as a chairperson as a result of the poll, he shall be the chairperson for rest of the meeting.
Power of a chairman. First, the chairman has prima facie authority to decide all questions which arise at a meeting and which require decision at the time. Second, the entry in the minutes book of the chairman's decision is evidence of the decision of the meeting. Third, the chairman has a right to decide priority among speakers, to demand poll, to exercise casting vote, to expel an unruly member, and he may, with the support of the majority, apply closure to a discussion after it has been reasonably debated. Fourth, he can also adjourn a meeting when it is impossible by reason of disorder or other like causes to conduct the meeting and complete business. Casting vote. Articles of association may give an additional or second vote to the chairman of the company, over and above his right to vote as an ordinary member. In the case of a tie, that is, equality of votes, chairman may use the casting vote to decide the matter in one way or the other. The duties of a chairman are: first, the chairman must take care to see that proper discipline is maintained at the meeting, that the proceedings are conducted in a proper manner, that proper opportunity is given to the members to express their views, that the voting is fair, and the proceedings of the meeting are properly and correctly recorded in the minutes book. Second, the chairman is expected to act bona fide according to his best ability and judgment, and without any prejudice. He should see that the meeting is duly convened and properly held. Let us now define the term proxy. The term proxy has two meanings. A. A personal representative of the member at a meeting, that is, the person authorized to act or vote for another at a meeting of the company, and b. the instrument by which a person is appointed to act for another at a meeting of the company, since a representative may be appointed only in writing.
Moving further, the provisions of the Companies Act regarding appointment and rights of proxy are: law entitles every member to appoint another person as his proxy to attend and vote at company meeting instead of himself or herself. However, a member of a company having no share capital does not have this right unless its articles of association otherwise provide. A member of a private company shall not be entitled to appoint more than one proxy to attend on the same occasion unless its articles of association provide otherwise. But a member of a public company may appoint more than one proxy. That is, he may appoint one proxy in respect of certain shares held by him or her and a different proxy for other shares held by him or her. Any person can be appointed as a proxy whether he or she is or is not a member of the company. In case the proxy is not a member of the company, he or she shall have no right to speak at the general meeting unless the articles otherwise provide. There is, however, no provision preventing a proxy putting questions in writing and sending the same to the chairperson for answer. A proxy is ordinarily entitled to vote only on a poll, but he or she may vote on voting by show of hands if the articles so provide. Besides that, he or she may demand or join in demanding a poll. Proxy must be appointed by an instrument in writing, duly stamped and signed by the member of the company. A blank but stamped proxy is valid and may be completed by the person authorized to do so. Proxy must be deposited with the company at least 48 hours before the commencement of the meeting. A company, however, cannot legally require proxies to be deposited with it earlier than 48 hours before the time of the meeting. After giving 3 days notice to the company, the members may inspect during business hours the proxies lodged with the company at any time during the period commencing 24 hours before the time fixed for the commencement of the meeting and ending with the conclusion of the meeting. Proxy lodged for the original meeting remains valid for the adjourned meeting as well. Every notice of a meeting must appropriately mention that a member is entitled to appoint a proxy and that the proxy need not be a member. A proxy is revocable. It can be revoked at any time. Death of the shareholder appointing a proxy will, in the absence of provisions in the articles, revoke the authority of the proxy. Shareholder may himself or herself attend and vote in the meeting. Vote tendered by the proxy in such an event or case will not be accepted because the need for exercising the proxy had never arisen. Proxy in this case shall stand revoked impliedly.
Let us discuss the procedure of voting at general meeting. The decisions at the meetings are taken by way of passing the resolutions at the meetings. Every proposed resolution is discussed by the members of the company. Members have the right to move amendments to the proposed resolutions, provided the amendments are germane to the proposed resolution. After a proposed resolution has been discussed, it is put to vote. Every member has a right to vote on such resolutions. Shareholders may exercise their voting rights in their best interests with complete freedom. They are allowed to vote even if their interest is in conflict with the interest of the company. A director may vote in the shareholders meeting even though his interest in the subject matter is opposed to the interest of the company. The preference shareholders have right to vote only on such resolutions which directly affect them, and when their dividends are in arrears for a specified number of years. Voting may be either by a show of hands or by a poll. Voting by show of hands. In the first instance, at any general meeting, voting takes place by a show of hands. On a show of hands, each member has only one vote. Proxies are not entitled to vote in case of such a voting unless the articles otherwise provide. The chairman's declaration on the result of voting by show of hands is conclusive. Voting by poll. Voting in accordance with the voting rights as given to the members by the Articles of Association is called a poll. Ordinarily, it implies exercise of voting rights by members in proportion to their share of the paid-up equity capital of a company. All decisions taken by voting by show of hands will stand cancelled as soon as a demand for voting by poll is made. It is the demand for poll and not its result which will eradicate the decision by show of hands. A poll can be demanded either before or after the declaration of the result of voting on a show of hands. A poll may be demanded by either of the following: A. Chairman on his own motion, or B. In the case of a public company having share capital by any member or members present in person or by proxy holding shares carrying not less than one-tenth of the total voting power in respect of the resolution, or having paid up share capital of not less than rupees 5 lakh, or C. In the case of any other company by any member or members present in person or by proxy and having not less than one-tenth of the total voting power. The demand for poll may be withdrawn at any time by the person or persons who made the demand. Poll must be held according to the provisions of the Articles of Association. Resolutions. A proposal, when passed and accepted by the members, becomes a resolution. The Companies Act provides for two types of resolutions. First, ordinary resolution. Second, special resolution. Ordinary resolution is passed by a simple majority of votes at general meeting, of which notice required by section 114 subsection 1st of the Companies Act has been duly given. Simple majority means that the votes cast either by show of hands or on a poll in favor of a particular proposal, including the casting vote of the chairman, exceed the votes cast against it. An ordinary resolution is required to pass the annual accounts, to declare dividends, to hold elections of directors, to appoint auditors, to issue shares at a discount, etc. Special resolution. It is passed by a majority of 3/4 of the votes in person or by proxy. In other words, the votes cast in favor of the resolution must not be less than 3 times the number of votes cast against the resolution. The intention to propose the resolution as a special resolution must specially be mentioned in the notice issued for calling the meeting. It must be accompanied by an explanatory statement. It must be passed exactly in the same terms as specified in the notice for the meeting.
There are two kinds of general meetings: annual general meeting and extraordinary general meeting. Annual general meeting, commonly known as the AGM, is a regular meeting of the shareholders of a company which is held annually. Extraordinary general meeting, popularly known as the EGM, may be called at any time by the directors of the company on their own or on the requisition of given number of members. A notice of at least 21 days is needed to call a general meeting. Members of a company have a right to appoint proxy to attend the meeting on his or her behalf. Voting at a meeting takes place first by show of hands and then by poll. Ordinary resolution is passed by a simple majority.